Doctor, how are you today?
I'm just fine. How are you doing today, sir?
Still, I don't know. It's been rough so far.
Well, I hope I'll be easy on you today.
Mr. Zeskind, how are you?
Morning, Your Honor. I'm doing all right. How are you doing?
All right. I hope so. All right. Motion to dismiss.
Good morning, Your Honor. Sam Zeskind of Oyster Helpman for the defendant, City of Homestead. My partner, Matt Mandel, is on the line as well.
Let me ask you a question, Mr. Zeskind, before you proceed. What's the standard of review on this particular case on a motion to dismiss the complaint?
On a motion to dismiss for collateral estoppel issues,
Yeah.
the prior proceedings that are the basis of the collateral estoppel claim, the prior judgment.
Can I go outside the four corners of the complaint?
No, Your Honor, but I'm not asking you to go outside the four corners of the complaint. What we're asking you to do, and the third DCA said that it's the proper procedure, is that even though collateral estoppel is usually an affirmative defense that would be addressed on summary judgment.
Correct, because in a usual collateral estoppel case, you would have to go outside the four corners of the complaint.
Right, but where, as is the case here, that prior proceeding and the judgment, and really all the facts you need to know from that case are incorporated into and alleged within the subject complaint,
Okay.
then you can consider it. So, Your Honor, we cite in our motion the case, the Kowalik versus Lee Rem case. It's a 183 Southern 3rd 1175. It's a 2016 4th DCA case. And that case says that even though collateral estoppel is usually an affirmative defense that is not typically addressed on a motion to dismiss, the court did find that it's appropriate for the court to consider the issue where a plaintiff specifically incorporates prior proceedings into his complaint. And we believe that that's been done here. In paragraph 7 through 15 of his amended complaint, it's an entire discussion about the prior case. If Your Honor only takes into consideration those allegations, the exhibits that he attaches to the complaint that actually include pleadings from the prior proceeding, and then look at the holding of the third DCA case that is the basis for collateral estoppel. In that case, Your Honor, is City of Homestead versus McDonough, 232 Southern 3rd 1069. It's a 2017 third DCA case. That all those things taken into consideration, you don't have to go outside the four corners of the complaint. I would point out, Your Honor, just procedurally, I'm sure you have other questions, but this, we're here on our motion to dismiss the amended complaint. The initial complaint in this case suffered from the same infirmities. We moved to dismiss. Judge Diaz was the judge on this case at that time. Judge Diaz granted the motion to dismiss. Obviously, plaintiff wasn't happy with that result. He moved for Judge Diaz to recuse himself.
My lucky
Ultimately,
day.
he did, and now we're here. The amended complaint hasn't cured any of those deficiencies. The plaintiff is still seeking to re-argue and relitigate the issues that were decided against him in the initial third DCA case. The public records requests are verbatim, exactly the same. The records at issue are the same. This case is primarily about the redaction of a single document where the city claimed the insurance claim negotiation exemption. That case, that exemption as it was applied to the exact same document was affirmed by the third DCA. It found that in the response to the prior public records request, the city properly withheld that document. So that issue has already been decided by the third. This court is compelled to follow the third DCA's ruling on that issue. And I know that plaintiff also in his complaint, beyond the redaction of that one document, also alleges that there were additional documents responsive to his request that weren't produced. I would point out, and you don't have to go outside the four corners of the complaint to consider this, Your Honor. In the initial in the original case, the third DCA says this within their opinion at page 1071, talking about the issue of the additional records. It says the trial court additionally denied McDonough's claim that the city violated Chapter 119 by failing to produce additional non-exempt responsive records. And that's at 1071 of that opinion. The court then ultimately, while it speaks in its final holding largely about the risk management claims file exemption, which is not at issue here, it does go on to say we affirm all remaining issues. So the third DCA affirmed that issue about whether or not there are additional non-exempt responsive records. That's been decided. So Your Honor doesn't have to go outside the four corners of the complaint, the exhibits to the complaint, or the opinion, which is the case law, to make your determination.
All right. Doctor?
Yes, sir, Your Honor. First, I'd like just to note that opposing counsel's lack of candor is astounding. I'll get right to the heart of the issue. In Request A, which was litigated in McDonough 1, which is the third DCA case that Mr. Zeskind is talking about, the city claimed only 5 records were responsive and claimed that all 5 were exempt. The third DCA upheld the exemptions and stated that they were valid until all issues related to the notice of intent were resolved. After the issues were resolved, Request 1 was filed. The facts at bar, Your Honor, are categorically not identical to McDonough 1. First, the exemptions had expired. Second, instead of stating all 5 records were exempt, this time city produced 3 records, claimed the 4th as exempt, and withheld the 5th, stating it was believed that this record was not wanted. And that goes to a comment made by Mr. Zeskind. He said the only argument is one email that was redacted. That was not my argument. They also failed to provide me the 5th record that they were claiming to be exempt, as well as other records. Third, a second larger set of records was provided to others who filed identical requests, but not to me. Your Honor, Mr. Zeskind talks about additional records and what were talked about in the third DCA. Those additional records were produced to me allegedly in a broader request that I filed. However, when the identical request was filed, not the broader request, they gave records to other people that were never provided to me. Fourth, Your Honor, Request 1 was made broader than Request A after the city had initially responded. This is not the same request anymore. And yet, even though I had broadened the scope of Request 1, the second set of records that were provided to others still were not provided to me. And lastly, Your Honor, opposing counsel has repeatedly provided a privilege log he knows to be deficient. This is not an exhaustive listing of the differences between the case at bar and McDonough 1. In Pierce v. Sandler, the third DCA provided the 5 elements of collateral estoppel. 1, the identical issues were presented in a prior proceeding. 2, there was a full and fair opportunity to litigate the issues in the prior proceeding. 3, the issues in the prior litigation were a critical and necessary part of the prior determination. 4, the parties in the 2 proceedings were identical. And 5, the issues were actually litigated in the prior proceeding. In comparison to McDonough 1, Your Honor, the issues herein are not identical. There was no opportunity to litigate them. They were not part of any determination, and they were not previously litigated. Instantly, the city can only meet the 4th element of collateral estoppel, i.e. that the parties are identical. As such, city's motion to dismiss is frivolous, and I respectfully request that it be denied.
Can you get the last one?
Your Honor, can I have just
one
more minute real quick?
Sure.
Your Honor, in the interest of judicial economy, I want to bring up this other issue. With respect to the 2 motions that we have that are awaiting orders, opposing counsel has filed 257-105 motions. Both letters were served 21 days before the respective hearings. However, both motions were amended, and letters addressing the amended motions have never been served or filed. As such, I believe these 57-105 motions are also frivolous. Further, the fact that the amended motions were taken under advisement after hearing strongly suggests that my motions are not frivolous. Therefore, in the interest of judicial economy, I ask if you prefer me to respond to the city's 57-105 motions with my own motions to strike under Rule 1.140 and set hearings, or is there another path you wish me to follow which will reduce the burden on this court?
This court is burdened already without you all, so it's not going to add anything to me. So go ahead and file. No, okay. I'm not going to do that on our tenancy. Just go file your motion.
Okay, I'll do that. Thank you, Your Honor.
All right. Mr. Zeskind, you have the last one.
Thank you, Your Honor. I'm glad that plaintiff brought up the Pierce v. Sandler case. We actually cite that case in our motion, and he appropriately quoted the 5 elements necessary for collateral estoppel, which we believe are satisfied here. But immediately following the third DCA describing the elements, it then goes on to say, where these elements are satisfied, collateral estoppel may be applied to bar subsequent causes of action, even where the second claim requires proof of different essential facts than those required to be proved in the initial suit. So plaintiff is trying to bring up these other facts related to other requesters that are really red herrings, that they're not relevant to the issues, which are the same. They are identical issues. Plaintiff just mentioned that the request is different because he says he broadened it. I just asked Your Honor to look at the amended complaint, which does not include any broadened request language. It only includes the verbatim language from the 2015 request. I know plaintiff just mentioned, and this would be the last point, Your Honor, that the fifth record he says was improperly withheld, and I would just point out that, since the city's response, I think, is included in the pleadings, and he references that it was withheld because of a statement made in court, that within the third DCA's opinion in the initial case, it actually references that fifth record specifically and says this: record 5 was acknowledged in open court by McDonough, and he was represented by counsel in that case, so it was by his counsel. Record 5 was acknowledged in open court by McDonough to be confidential, privileged, and exempt.
Okay.
And that was at 1070 to 1071, and that was the basis for withholding it in this case, that his counsel acknowledged on his behalf in open court in the other case that record need not be produced. That issue doesn't need to be relitigated here. It's been addressed already in the third DCA's opinion. Everything that plaintiff is seeking, every relief and claim that he's asserted in his amended petition, has already been resolved 4 years ago by the third DCA in favor of the city and against plaintiff. There's no room for relitigating those issues. They're barred by collateral estoppel. And Your Honor, we ask that you grant the city's motion to dismiss with prejudice.
Okay. Your motion is denied. I will see you at summary judgment.
Thank you very much, Your Honor.
You got 20 days to answer.
Thank you.
Have a good day.
I'm sorry, Your Honor, real quick. Just make sure I understand. He has 20 days to answer the amended complaint?
Yes.
Thank you very much, Your Honor. You have a great weekend, sir.
You too.